We spend so much time talking about settling your case, how to get the most amount of money. It's a bright, juicy topic. Everyone loves talking about money, settlements. But MMI is the precursor to your settlement. It's the most important part of your case that leads up to the settlement, and it's what you need to know when you're coming down to maximizing settlement value. So today we're going to talk about the top workers' compensation MMI mistakes that can cost you thousands. What is MMI, and why is it such an important part of your workers' compensation case? MMI is maximum medical improvement. It is when you've recovered to the point where your doctors think you're not going to get any better. You've plateaued. There's no other treatment that they could give you that's going to improve your condition. And sometimes it comes down to surgical issues. There's a lot of people out there that don't want to have surgeries. We've had clients that decline surgeries for religious reasons. But if you're at the point where your doctor's saying you need surgery and you say, I'm not having surgery, well, maybe you're now at MMI, or maybe you had your surgery and you've recovered from your surgery and you've gotten as good as you're going to get. MMI is maximum medical improvement. It does not mean that you're 100% better. It does not mean that you're fully healed. It does not mean that your case is over. You can reach MMI and still be very severely disabled. It's just that point where your level of disability is no longer fluctuating. Now, it's super important with a workers' compensation case for you to understand and distinguish what type of injuries you have in order to determine which way your case is going. You have to distinguish between scheduled loss of use, injuries to your arms, legs, hands, feet, fingers, and toes. It could include hearing and vision, but generally they're extremity injuries versus non-schedulable injuries. And your non-schedulable injuries are really what we're going to focus on today. Those are your head, neck, and back injuries. There's so many back injuries. It's probably the most injured body part overall, which is why we're going to spend so much time discussing non-schedulable injuries, which result in permanent partial disabilities generally. So you get hurt, you have your accident. Generally, you're totally disabled following your accident initially. And as time goes on and you get treatment and physical therapy and chiropractic care, and your injury gets better. Doesn't mean it gets 100% better, but you do recover from your injury as time goes on. Treatment is there to help you. And you eventually reach that point of maximum medical improvement. Once a judge determines that you've reached maximum medical improvement, or your doctor and the insurance company doctor agree that you've reached maximum medical improvement, your temporary benefits stop around that point in time. And you kind of move into the permanent disability phase, because MMI is the beginning of determining permanent disability. So around that time is when your temporary disability benefits will come to an end and your permanent disability benefits hopefully will pick up. And sometimes you won't even realize there's a difference. Sometimes the judge will make a finding that your permanent level of disability was the same as your temporary level of disability just before that decision was made, and you'll be getting the same amount of money straight through and you won't even know the difference. Sometimes, if you have a good lawyer like me, we're able to argue that your level of permanent disability is greater than the money you've been receiving up until that point. So maybe you've been getting paid at a 65 or a 50% rate of compensation, and we're able to prove that you have a 75% permanent disability. Well, maybe your money's going to go up. And by the same token, there could be a finding that your level of disability has decreased and you might actually get less money. So once that transition is made, oftentimes there could be a change in your compensation. And the worst part of it, in circumstances, especially when your doctors have determined or the judges determine that you have a partial disability just before you reach that stage of permanency finding, sometimes you are required to do a work search. And if your work search isn't sufficient, a judge might suspend your benefits and you get nothing until you could prove that you've done a good work search and convince them to start your benefits up again. It's a little tricky tool that insurance companies pull very, very often. This is where we see the biggest mistakes in cases. This is where problems pop up. What are the biggest MMI mistakes injured workers make in their workers' compensation case? Number one is assuming your benefits continue automatically after you reach maximum medical improvement. So people think, well, I've been temporarily disabled for so long that at this point in time, now that my doctor's found me at maximum medical improvement, I'm going to get more money and it's going to continue, and I'm permanently disabled now. This is just going to progress on its own. And that's wrong. Maximum medical improvement findings end your temporary benefits, and they don't continue just by default. To keep getting paid, you need to get a permanent disability ranking from your doctor. And God forbid, if work search has been required, you need to do a good work search. And your doctor has to file a form. It's called a C4.3 here in New York State. It's the workers' compensation form where MMI is assessed, and the doctor has to articulate his reasons for why you've reached maximum medical improvement and what his opinions are with respect to your permanent disability. You could find that form on the board's website. You could bring a blank one. My clients do it all the time. I give them blank 4.3s. Here, take a look at this. Get comfortable and familiar with it. This way, if you have questions, go ask your doctor when you go speak to him. Bring the blank form. Hey, let's go through this, doc. It's not always automatic. Your doctor is supposed to file that form when he finds that you've reached maximum medical improvement. Many doctors don't do that. that. And oftentimes it is directed by the law judge. The judge will say, claimant to produce a C4.3 within 60 or 90 days or whatever it is. And on that C4.3 form, there is a box before anything else that says, has the patient reached maximum medical improvement? Yes or no? If no, explain why. If there's no C4.3, then you have no rating. If there's no rating of permanency, then it's very possible you get no permanent benefits, or you're stuck with the findings that the insurance company's doctor has made, and you usually don't want that. What other mistakes? Ignoring the insurance company's report of MMI, and that's what we were just talking about. You go to see their doctor. They are going to send you a report explaining their findings and their conclusions. Oftentimes, the insurance company doctor will conclude that you've reached maximum medical improvement before your doctor. If that happens, once the board receives that, they issue a notice to the parties, to you and your lawyer, and they say, we've received this report that's giving permanent disability. It's time to get yours. And they usually give you 30, 60, 90 days to respond, but you're now on the clock to go get your own report from your own doctor. And if you don't get it done in the time frame they tell you, you are jeopardizing your claim, because it could make a finding that you are precluded from producing that report, and now you're stuck with what their doctor has to say. It goes right to your disability ratings. Disability ratings tell us how much you get, how long you get it for, and you don't want their doctor to be the one driving the ship there, because it's going to hurt you. Your own doctor should submit his own report giving his opinions on your permanent disability, whether you've reached MMI or not, and if so, what he feels your level of permanent disability is. And if there's a conflict, as there so often is, the board will either administratively, they'll send a letter out and they'll say, hey, there's a disagreement here as to the level of permanent disability. Take depositions of all the doctors that you want and file your arguments, and either they'll give you a hearing or they'll file a reserve decision, which they do outside of the presence of the parties. But oftentimes you get a hearing and it's judge, their doctor says this, our doctor says this, and you either try to work it out, and if not, you go to depositions and you litigate the case, try to show that their doctor was wrong and your doctor was right, and that your disability is more severe, and try to get you the benefits that you are entitled to. If you don't challenge the insurance company's doctor's findings with your own doctor's findings, you're going to get stuck with them. And the board is not very lenient when your doctor fails to file those reports in time. Make sure you keep those deadlines in mind. Make sure you make those appointments as soon as possible to go see your doctor. One huge mistake, we get a notice from the board and you have 60 days to produce your permanency report. You have 2 months to go see the doctor and to get an assessment on permanent disability and get it into the board so we can move your case forward. And people say, all right, I'll get around to it. You don't understand how busy doctors are. Doctors' offices are busy. They're crazy busy. And getting an appointment in time for them to then draft a report, have it transcribed, have it issued, have it billed and sent to the board, 2 months is not a lot of time. So once you get that notice that you have to go get that report, you better be on the phone with your doctor that day or the next morning scheduling your appointment. Don't wait, because it's only going to hurt you. Mistake number 4, settling at the wrong time. Settlement usually comes around the time of MMI, because there's still some question as to how significant the permanent injury is and how much money the insurance company is going to be responsible for. And when it comes to MMI, there's also a question that maybe you're not an MMI. Maybe you haven't reached maximum medical improvement. Maybe you do need another surgery that's going to cost a whole ton of money, and maybe you don't want that surgery. So that's when you want to start getting into settlement discussions. When you're ready, you want to do it as quickly as you're ready before you reach maximum medical improvement, because there's still some uncertainty as to what that case is worth. Timing is really everything here. If you settle too early, you might miss out on some major value with your case. If you settle too late, if a judge determines that you've reached maximum medical improvement, he finds that you have a 30% permanent disability, gets you 250 weeks of compensation. So let's say after a year of being injured, if you sit back and wait 2 years, 104 weeks into that, well, now there's only 146 weeks of compensation left to you. How much is your case really worth at that point in time? You bought down your own case. You did get those weekly checks, but that big settlement check at the end is not going to be as nice as you thought. So you don't want to wait too long. The sweet spot is right around the time of maximum medical improvement, before the judge finds your permanency rating. Once that decision is made, you're locked in. Number 5, big mistake, accepting a lump sum settlement of Section 32 without a long-term plan. After you've reached maximum medical improvement, many insurance companies will offer to close out your overall case with a Section 32. And it might be nice to get a nice big fat check, but maybe you do need maintenance care. Maybe you do need the ability to go back to see the chiropractor once every 6 months. And if you settle your case with a full and final Section 32, the responsibility to pay for that is yours. That's something you really need to consider. So you should talk to your doctors about what to expect if you do settle your case. A lot of times clients will go and speak with their doctors and their physical therapists, and they'll say, hey, even though my doctor's requesting I go for a lot more physical therapy, the physical therapist taught me all these different home exercises I can do, which would help me. And that's a lot of the same stuff I do at physical therapy. Maybe it's a good time to settle my case and I can maintain myself with home exercise. And maybe that's a smart way of going anyone about it. So you want to prepare and plan for your future once you do settle that case. When we do a full and final settlement of your case, virtually every time we allocate money, if it's not required by Medicare, for your future medical care. So the percentage of money in your settlement that's there for you to use for your future medical treatment, when you are required to do so by Medicare, it's a formalized number that you have to set aside, you have to use for your future medical care. But your settlement is in place for you to care for yourself, including your future medical, and there's money there for you for that. And make sure you plan for that. Make sure you plan for other expenses you have in your life, child support, things like that. If you take a lump sum, a full and final Section 32, once your case is closed, it is closed forever. The only way a Section 32 can ever be reopened is if all the parties to that agreement, including the board, agree to reopen that case. I have never seen it done with any of my cases and my clients. What's the next big mistake? Not showing that you're attached to the labor market after maximum medical improvement. And this is probably the biggest pitfall, which pops up at the end of the case. What'll happen is you're getting your temporary disability benefits, and your doctor has maintained all along that you have a total disability. You haven't gotten much better. The insurance company doctor says, well, maybe you have a 75% disability, and that's gone down to a 50% disability. And they are arguing that you have a partial disability. We're going to reach some compromised rate while you're hurt and while you're temporarily disabled. But once your doctor files that C4.3 form, the doctor is required to check off what your work capacity is. And unfortunately, on that form, there's check boxes for heavy work, very heavy work, medium work, light duty work, sedentary work, less than sedentary work, but there's no checkbox for total disability, no work. So your doctor's kind of forced to check off a box, and unless he puts in a really nice narrative report saying, I'm checking this box only because there's no other box, and my patient is totally disabled, your doctor's checking a box saying you can do some work, and insurance companies will jump on that and say, well, now you're partially disabled, now you have to go look for work. You have to go put in a good faith work search effort and show the judge that you've done everything you can, try to get back to work, look for every job you can within your restrictions, and either you do and you find a job and that's great, and maybe you have a reduced earnings claim, or you can't, and you got to prove to the judge that, Judge, I've done everything I can and I just can't find a job. And you better hope the judge agrees with you, that the judge says, you know what, yes, you have done a very good job, you've tried hard, and I'll continue your benefits. But if the judge doesn't agree, if the judge says, I don't think you've done a very good job, I think you're just kind of doing the bare minimum here, well, then your benefits are going to get suspended. And regardless of what your level of permanent disability is found to be at that point, it's not going to matter, because you're not going to get a single dollar from workers' compensation until you reattach to the labor market. And it's the worst place on earth to be with respect to a workers' compensation claim. And I see this happen with my clients from time to time. We try to do everything we can to slalom through the claim to avoid this, but sometimes it's inevitable, because to be honest, not everybody's totally disabled. There comes a point in time where your injuries have settled and you've reached that point of maximum medical improvement and you're not 100% disabled. So you have to look for work within your restrictions in order to keep your money coming to you. Be prepared to look for work when you're approaching maximum medical improvement. Keep records of your work searches. This is a time when you can make your own evidence to support you. Print out those job postings from Indeed. Print out the application that you filled out. Write down the phone calls you make. Who did you call? What time did you call them? The insurance company has a right to those job logs and that evidence, and they will follow up. They will call Mike at Mike's Deli and say, hey, 3 weeks ago, did Juan Soto call you for a stockroom job? And if Mike says, I don't know what the hell you're talking about, that's going to hurt you. But if Mike says, yeah, Juan Soto called me, and I'm sorry, I can't hire a guy with 2 bum knees and a bad back, it'll help you to show that you were honest and you actually gave it a good try. Another big mistake, not keeping records during and after you reach maximum medical improvement. Every form, every report matters. Doctor's notes, IME reports, letters from the board, decisions, and all those documents that you are collecting during your work search if you're required to do a work search. Your paperwork is your defense. Hold on to all your documentation. Keep all your paperwork in a folder. Keep it all in one place. If there's any disputes, any problems, any inconsistencies, bring your folder to me. Another big mistake. People assume that once a finding of maximum medical improvement, MMI, is made, that there can't be any discussion as to a change in condition. They don't want to be locked in, because what happens if my condition gets worse? And it's a very valid concern. If things get worse, you might be able to reopen your case. If you've settled with a Section 32, not so much. But if you have reached that point where you've reached maximum medical improvement and a judge has made a determination, you might be able to reopen your case for additional ongoing active treatment, not symptomatic maintenance care, but active care if something gets worse. And you could potentially move to reclassify if your condition changes significantly. So if a judge makes a determination as to your level of disability, or if your lawyer reaches an agreement with the insurance company and you have not done a Section 32 settlement, yes, you could potentially reopen, reclassify, and get treatment that you need moving forward. Generally, you have 15 years from the date of closure to do that, aside from a Section 32. If your case is still open or only partially settled, because sometimes we do partial settlements where we settle the indemnity side, but leave the medical open, you might still have options moving forward. You're locked in, but you're not fully locked in. There is a key. The last big mistake that I see, and the biggest, is trying to do it alone. We do this every day. Workers' compensation attorneys do this every day. It's a very specialized thing that it's a very difficult thing to handle on your own. Without a lawyer, there is a risk. There is a chance that you're going to be taken advantage of by the insurance company's attorneys, and you don't want that to happen. You want to have somebody that's there for you who's going to try to get you everything that you're entitled to. These insurance companies aren't just one lawyer. They have legal teams, and you don't want to go in there alone. Having an attorney, it really will help you in the long run. Call a lawyer, get some input, get some advice, get some direction, and hopefully they can help you do the best you can and maximize those benefits. If you want to call me, 212-406-8989. I'm always here to help. I love you guys. You're all fantastic people. Love you. Thank you. And I hope to see you guys. Be safe. Bye-bye.